Good afternoon. My name is James Bacon. I'm the attorney representing the Croton Watershed Clean Water Coalition and certain residents in the Southern Tier. I wanted to thank the committee for holding this very important public hearing today, and also for many of its insightful comments and questions to the previous panels. I find it very disturbing that DEC decided not to come here, and I think they would have learned something from the questions, and also the public would have learned something from their responses to the committee's questions. I would hope that in the future that the committee suggest or consider using its subpoena power to require DEC to come in and to have it answer your questions. All right, so we are deeply concerned with DEC's response to comment 4232 in its assessment of public comment on the draft regulations for high-volume hydraulic fracturing, or HVHF. Response 4232 indicates DEC will interpret the law of capture to include non-migratory gas, thereby condoning subsurface trespass and the taking of private property. As background, New York follows the law of capture, which is that a migratory substance, such as oil or gas, is not owned until a landowner drills and gains possession of it. The state's oil and gas regulations assume that all gas is migratory. Therefore, DEC requires spacing units dedicating land to one driller so that multiple wells will not depressurize underground pools and cause waste. This process is also called unitization. Any landowner refusing to be unitized will be forced into a spacing unit by compulsory integration to prevent pool depressurization from additional drilling. Draining the migratory gas from beneath properties in the spacing unit is not trespass because the well bore never invades other properties and the draining process causes no harm. While DEC defines all natural gas as migratory, the oil and gas industry distinguishes between conventional and unconventional gas based upon geology and the mining technique. The industry defines HVHF as an unconventional technique that extracts unconventional gas. A deep vertical well is drilled, and then the well bore is directed horizontally into a thin layer of source rock, such as the Marcellus, Utica, or Trenton Black River shale. Boring is followed by high-pressure fracturing of the shale's minute pores to extract the gas. To protect homeowners' rights, DEC must update its regulations to define conventional gas as migratory gas extracted from pools without artificial stimuli, and define unconventional gas as non-migratory gas trapped in an impermeable sediment and extracted by unconventional means such as hydrofracturing, acidization, or pressurization. Significantly, DEC's 4232 response indicates it will not distinguish between conventional and unconventional gas, and thus will expand the law of capture to grant a driller ownership of all non-migratory gas beneath all properties in a spacing unit. Therefore, for the first time in New York, compulsory integration would render homeowners powerless to protect their property from well bores invading their subsurface, opening fissures beneath it, and injecting hazardous materials into it and taking their non-migratory minerals. That type of property invasion is permitted in some western states, such as North Dakota, because that state's oil and gas policy subordinates individual rights to the industry, and its courts hold that compulsory integration is a proper exercise of the state's police power that supersedes the law of trespass. By contrast, our state's oil and gas policy protects individual rights. It states that the production of oil and gas must be regulated in a manner whereby, quote, the rights of all persons, including landowners and the general public, may be fully protected, end quote. However, if DEC's policy in response 4232 is not revised, and I included the comment and a response in my copy to the committee, individual rights will suffer permanent harm. Not only will compulsory integration subject landowners to subsurface trespass, the disposal of hazardous frac fluids beneath their lands will prevent those homeowners from obtaining mortgages or refinancing and will taint the marketability of their title. As the work of Greg May, who's I think the Vice President of Lending in Tompkins County, has shown time and time again. The industrial use of a homeowner's property for HVHF would also violate the typical homeowner's residential use only mortgage restriction. DEC can prevent that permanent damage to the homeowner by defining conventional gas as migratory, defining unconventional gas as non-migratory, and by limiting the establishment of spacing units for the drilling and extraction of migratory gas only. That better reflects legislative purpose for unitization and its historical application in New York. If DEC refuses to do so, we request that the legislature adopt definitions for conventional and unconventional gas and limit unitization in order to prevent DEC from skewering the state's oil and gas policy and trampling individual rights. Compulsory integration should not be expanded to upend New York's law of trespass and take from a homeowner his most significant investment. Thank you.
Thank you. But I have a question for Mr. Bacon, and this is maybe the one area in this topic where those of us who are lawyers have an advantage over the scientists and the engineers. The compulsory integration legislation. First of all, can you tell me how long ago it originated in New York? I mean, I've heard discussion of it being amended in '05. Is that when it was enacted, or? No,
I think it had been in place since 1963, because the traditional idea of pools of oil and gas were that it is beneath the ground, and you wanted to avoid waste and depressurization by limiting the number of basically straws that go down into the pool. And so the 2005 amendments didn't change anything from the 1963 original legislation.
And has it been tested in court in New York? No, hasn't been tested in court in New York. In Texas, there's a Supreme Court case, well, the highest court in Texas, I think it's Coastal Associates versus Garza. And the dissent there said, well, certainly if you're going to direct a wellbore beneath somebody else's property, that's trespass. But the majority basically sidestepped it, and because the oil and gas industry is so important to the economy in Texas, they didn't really want to deal with it. Now, North Dakota, in this case that I cite in my paper that I gave you, the North Dakota court said definitely the oil and gas policy in North Dakota subordinates the rights of individuals to the industry, and this is too important of a resource. But the oil and gas policy, you know, again, it doesn't say what New York's policy says, which is that it does protect the public health or the public rights and individual rights, which is a very big difference. I mean, I've seen a summary of the compulsory integration law. Does it authorize me to drill horizontally into my neighbor's land? You know, it's silent on that, but DEC's response to that 4232 question shows that they are going to continue to interpret the law of capture to include all properties within the spacing unit. So they don't come right out and say, well, we're going to allow subsurface trespass, but they say you're going to be, if you're drilling in a spacing unit, you are entitled to all of that resource that's beneath all those properties in the spacing unit, and there's only one way to get that resource from those properties in Marcellus Shale, and that's either to direct the wellbore beneath it or direct the hydrofractures beneath other people's property and take that mineral, because it's non-migratory. I mean, I would think there is an enormous difference between saying I can drill into my own subterranean land, and if nature has your resources flow into my land, you know, too bad for you. It strikes me as being profoundly different to say I can enter your land as long as I'm 5,000 feet down. Well, I'm heartened to hear you say that, because I feel the same way, and DEC is not addressing this, and that's why those definitions need to be clarified for unconventional gas and conventional gas, and make sure that conventional gas is migratory gas only, and they restrict spacing units to getting that type of gas and not the non-migratory gas, and that would solve it, I think. Okay, well, that strikes me as something that, first of all, we in the legislature might want to look at and perhaps clarify or try to, or secondly, that if fracking does go forward, may well be something to litigate. Yeah, I would also point out there's a terrific law review article about this from the Cornell Law School that was written last year, and it's about it does a terrific job
going through the historical nature of the law of capture, and brings up these problems with shale gas and coal bed methane gas and different types of scenarios, and looking at the other states, how they've
If you could email me a citation to that, I would appreciate that.
I'd be happy to.
Okay, thank you.
Well, thank you.
Thank you all very much. Appreciate it.